Hi again, I'm Neal Fugate, and welcome to my video series, Understanding the RPA. This is part 4. In part 3, we made it through page 5 of the RPA, and in this video, we're going to continue with the RPA itself. As you may remember, the download packet that comes with the RPA consists of a number of other documents, and this is the list. By the end of this series, we will have gone through all of those documents. And as another reminder, the RPA is the contract for the transaction, and only the buyers and the sellers are parties to the agreement. A good rule of thumb is to remember if it's not in writing, it doesn't exist. So we ended part 3 on page 5, now on to page 6. Okay, page 6 starts with paragraph 14, which deals with the time periods, removal of contingencies, and cancellation rights. And just to point this out, any mutual written agreement or removal of contingencies or cancellation under this paragraph by either the buyer or the seller must be exercised in good faith and in writing. That's why at the beginning of these videos I have stated over and over again that if it isn't in writing, it doesn't exist. On to 14a. The seller has 7 or a different amount of days, if agreed upon, after acceptance to deliver to the buyer all reports and disclosures and information for which the seller is responsible. And in B, the buyer has 17 days, unless another time period is agreed upon, after acceptance to complete all of their buyer investigations, review all disclosures, reports, lease documents, etc. Within the time period specified above, the buyer may request that the seller make repairs or take other action, but I wanted to call this to your attention. The seller has no obligation to agree to or respond to that request. Going further, at the end of the time specified above, or as otherwise specified in the agreement, the buyer shall deliver to the seller a removal of all the applicable contingencies or cancel the agreement. But if, moving down here to the next highlighted part, if the seller hasn't delivered the disclosures that they're responsible for within the time specified in the paragraph above, then the buyer has 5 days after delivery of any of those items, or the time specified in a paragraph above, whichever is later. Which means that if the seller hasn't delivered the disclosures that they should have delivered in the 7-day period originally, that when they do deliver those, it gives the buyer an additional 5 days to do their review of those disclosures. It in effect extends their due date for their contingency. Continuation of contingency. Even after the end of the time specified in the paragraph above and before the seller cancels, if they do, the buyer retains the right in writing to either remove the remaining contingencies or cancel the agreement on a remaining contingency. And once the buyer's written removal of all contingencies is delivered to the seller may not cancel this agreement pursuant to paragraph 14d(1) below. 14c discusses the removal of contingencies with the offer. If the buyer wanted to, they could actually submit an offer and remove the contingencies right here. So it would be an offer with no contingencies. There may be some time when that would make sense, but normally I wouldn't recommend that because the buyer is leaving themselves wide open. You might run into a situation where the seller is demanding that, but in that case, buyer beware. 14D, the seller's right to cancel. If by the time specified in the agreement the buyer hasn't removed the applicable contingencies or canceled the agreement, the seller, after first delivering to the buyer a notice to buyer to perform, may cancel the agreement. And if that happens, the seller shall authorize the return of the buyer's deposit, except for fees that the buyer incurred already in the escrow. But be aware that before the seller can cancel, they have to deliver to the buyer a notice to buyer to perform, which is an NBP. And then they can cancel the agreement if the buyer hasn't met certain criteria which are covered in this paragraph. Because of this, 2 days before the deadline for an action to be taken, the buyer or seller's agent can present the other party with a notice to perform at a certain date. It can't be more than 2 days before the due date, and it gives the other party 2 days to act. It might sound a little complicated, but I just wanted to put that out there so you do have an understanding of it. And if we were in a real transaction, I would give you a much more thorough explanation, and it may never come up, but just to let you know. Section 14F, regarding the effect of the buyer's removal of contingencies. I can't stress how important this is to buyers. If the buyer removes in writing any contingency or cancellation rights, the buyer shall conclusively be deemed to have completed all their investigations and reviewed all the reports and everything, all the disclosures, and elected to proceed with the transaction. And finally, they're saying that they've assumed all liability and responsibility and expense for repairs or corrections pertaining to that contingency or cancellation right, or for the inability to obtain financing. When you remove the contingencies, you've basically removed your protection. 14G talks about the close of escrow. Before a buyer or seller may cancel the agreement for failure of the other party to close escrow, according to the agreement, the buyer or seller must first deliver to the other party a demand to close escrow, and that's on Form DCE. And it must be signed by the applicable buyer or seller, and it gives the other party at least 3 days, or otherwise agreed upon, after delivery to close escrow. A delivery to close escrow may not be delivered any earlier than 3 days prior to the scheduled close of escrow. So in that way, it's like a notice to perform, except the notice to perform gives 2 days on either side. This gives you 3 days after delivery to close escrow, but it cannot be delivered prior to 3 days to the scheduled close of escrow. And once again, if we were in a transaction and this looked like it was going to be an issue, I would go through this more thoroughly with you. Section H talks about the effect of cancellation on deposits. And if a buyer or seller gives written notice under the rights that they have under the agreement, then the parties shall agree to sign mutual instructions to cancel the sale and escrow and release deposits, if any, to the party entitled to the funds, less fees and costs incurred by the party. Those would typically go to escrow or service providers or other vendors that have already performed services in the course of the escrow. And except as specified above, release of funds will require mutual signed release instructions from the parties or the judicial decision or arbitration award. And then if either party fails to execute the mutual instructions, then the other party can make a written demand to the escrow holder for the deposit. And the escrow holder, upon receipt, shall give a notice of that to the other party. And if within 10 days after the escrow holder's notice, the other party does not object to the demand, the escrow holder shall disperse the deposit to the party making the demand. And as a footnote, a party may be subject to a civil penalty of up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists as to who is entitled to the deposited funds. On to page 7. Page 7, section 15, discusses the final verification of condition, and it gives the buyer a right to make a final walk through the property within 5 days prior to close of escrow. Now, it's not a contingency of the sale, but it's to confirm that the property is maintained basically in the same condition that it was when the offer was made, and that repairs have been completed as agreed upon, and that the seller has complied with the other obligations under the agreement. Repairs need to be completed prior to that final walkthrough, unless agreed upon otherwise in writing. And the seller shall obtain invoices and paid receipts for repairs, prepare a written statement indicating the repairs performed by the seller and the date of the repairs, and provide copies of invoices and paid receipts and statements to the buyer prior to final verification of condition. Section 17 deals with prorations of property taxes and other items. Normally, there are going to be certain items that will be paid current and prorated between the buyer and the seller as of close of escrow, and they are detailed in this paragraph. And escrow normally would cover those with you as well. Section 18 talks about brokers, and as noted before, the brokers and their agents are only parties to the escrow as far as compensation is required. And it is detailed here that compensation is payable upon close of escrow, and the other specifics on how that works. And in B, for the scope of duty, brokers and their agents are responsible for certain things, and other things we are not. We don't practice law. We don't give tax advice. We don't tell you how much to pay for the home. We don't tell you how much to sell a home for. But all of those specifics are covered in this paragraph here. Section 19 talks about representative capacity. I touched on that earlier, but if one or more party is signing the agreement in a representative capacity and not for him or herself, then that's going to be indicated in paragraph 31 or 32, and there has to be a representative capacity signature disclosure form as well. Section 20 talks about the joint escrow instructions to the escrow holder, and as I called to your attention at the beginning of the video series, the RPA is the residential purchase agreement and joint escrow instructions, and this details what the escrow company will follow from the agreement, and it's specified in detail with all the different paragraphs that they incorporate to the escrow instructions. Section B simply states that a copy of the agreement plus any counteroffers and addenda need to be delivered to the escrow holder within 3 days after acceptance. And then the validity of the agreement, as between the buyer and the seller, is not affected by whether or when escrow holder signs this agreement. The contract is actually valid once both parties sign off on it. And moving on to page 8, section C, once again, it states that brokers are party to the escrow for the sole purpose of compensation only as per the agreement. These other details deal with what the escrow holder does with some of the paperwork involved. And if you had any questions about that, I could clarify that as well. Paragraph 21 talks about remedies for buyer's breach of contract. And basically it states that any remedies that the parties want to establish have to satisfy the statutory liquidated damages requirements set forth in the Civil Code. So you can't just make things up. You have to follow what's already been established. And furthermore, in 21B, liquidated damages, if the buyer fails to complete this purchase because of a default, the seller shall retain as liquidated damages the deposit actually paid. If the buyer only put down 1% as an earnest money deposit, that's the most that the seller could actually go after. And moving forward, the amount retained shall be no more than 3% of the purchase price. That's why I said when we were talking about the earnest money deposit on page 1, it really doesn't make sense for the buyer to put down any more than 3% of the sales price. It may sound good, but the seller would have no way of going after anything more than 3% if, for whatever reason, the buyer defaulted on the agreement. Also, regarding liquidated damages, if you would like more information, below the video I'm going to include a link to a quick guide to liquidated damages that the California Association of Realtors produced, and I think it will be very helpful in answering any questions that you may have. As far as the dispute resolution section goes, mediation and arbitration are generally part of the agreement, and both buyer and seller have to agree to abide by these sections. But I'm including a link below to a quick guide from the California Association of Realtors that gives you a lot of detail about these. That's I usually provide that information to my clients in regard to these sections because I'm not a lawyer, but they can get a better idea of what is involved by looking over those documents. So I've included that below this video as well. Section C just talks about the additional terms that are used in mediation and arbitration, and those are here. Section 23 talks about selection of service providers, and while brokers and their agents are generally happy to refer clients to service providers to use in the transaction, we do not guarantee the performance of those providers. So that's covered here in section 23. The multiple listing service, brokers, according to the agreement, are authorized to report to the multiple listing service changes in the transaction. And that's even if the seller doesn't want the property on the MLS, we still need to update the files when there are changes to it. Attorney fees, if by some reason there's litigation, this states that the prevailing buyer or seller shall be entitled to reasonable attorney fees and costs from the non-prevailing buyer or seller, except as provided in paragraph 22A. So that's covered in the mediation and arbitration clauses. Section 26 talks about assignment. And there may be situations where a buyer wants to assign their interest in the contract to another party. Now, that can be done, but this states very clearly that it cannot be done without first having obtained the separate written consent of the seller to a specified assignee. And That would be the case if somebody wanted to wholesale a property. They would need to get the approval of the seller first. Or if a buyer needed to bring on another buyer in order to be able to get the loan or to close the deal, that would also be covered in this section. And if that were to happen, the seller would need to authorize that additional buyer as well, even if the original buyer was still part of the transaction. And it's also important to note that any total or partial assignment shall not relieve the buyer of the buyer's obligations pursuant to this agreement, unless otherwise agreed in writing by the seller. So if the seller agrees to have somebody else take over the either all or part of the contract, the original buyer is still responsible to make sure that they fulfill their duties unless there's a separate written agreement that releases them from that. Paragraph 27 states regarding equal housing opportunity that the property is sold in compliance with all federal, state, and local anti-discrimination laws. Paragraph 28 discusses terms and conditions of the offer. It states that this is an offer to purchase the property on the above terms and conditions, and then it goes on to state that the liquidated damages paragraph or the arbitration of disputes paragraph is incorporated in the agreement if initialed by all parties or if incorporated by mutual agreement in a counteroffer or addendum. And what I wanted to note is that if at least one but not all parties initial, a counteroffer is required until agreement is reached. The seller has the right to continue to offer the property for sale and to accept any other offer at any time prior to notification of acceptance. So it's all or nothing. Either both parties agree or neither agree. And normally this is incorporated. That's why I've included the links to the quick guides below, so you have a better understanding of it. I don't want you to be intimidated by these paragraphs. I just want to make them as clear as possible. But time is of the essence. All understandings between the parties are incorporated in this agreement. And finally, it says that neither this agreement nor any provision in it may be extended, amended, modified, altered, or changed except in writing, signed by both buyer and seller. Once again, like I said earlier, if it isn't in writing, it doesn't exist. Paragraph 30 is a list of definitions as used in the contract. And I wanted to note specifically that 30F defines days as calendar days, but the last day for performance of any act required by this agreement, including the close of escrow, shall not include any Saturday, Sunday, or legal holiday, and shall instead be the next day. So, normally when I start a transaction, once it's been accepted, I mark a calendar backwards from the days that certain things are due, and when that happens on a weekend, I allow for that. So if you were working with me, we would pretty much know that up front once an agreement was accepted. But I just wanted to clarify that to you as well. The other definitions, I will leave that up to you to go through at your own discretion. Expiration of offer, by default, it defaults to the third day after the offer is signed by the buyer. So when a buyer makes an offer to a seller, the seller basically has 3 days to respond. And in actual fact, if it was the 4th or 5th day and the buyer was still interested and they received the offer back from the seller, they could accept it and move forward if they wanted to. But just to let you know that part. That's page 9, and now page 10, we go to acceptance of the offer. In 32, we talk about the acceptance of the offer, and in it, the seller warrants that they are indeed the owner of the property and that they have the authority to execute the agreement. And it also states that the seller has read and acknowledges receipt of a copy of the agreement and authorizes the broker to deliver a signed copy to the buyer. Now, right here, if this is checked, the seller has accepted it, but it is subject to a counter offer. And that's very important to note. If you receive an offer back from a seller and this isn't checked, then that means that they're accepting the offer as is, as you presented it. But if this is checked, then there are going to be additional forms that have counters to the offer that they are giving back to you to say, okay, I'll accept it, but you need to agree to these terms as well. That the next little checkbox is if there is somebody signing as a representative for one of the parties. And other than that, this is where the seller would sign and date it. And if there were so many sellers involved that you couldn't fit all their names in those spaces above, then they would also need to do an additional signature addendum and check this box right here. And in this section, the confirmation of acceptance, this is where the buyer or their agent would initial to show that they received the accepted offer back from the seller. And the key thing to note here is that even if this isn't initialed, the binding agreement is created when a copy of the signed acceptance is personally received by the buyer or their authorized agent, whether or not confirmed in this document. This isn't the legal part. The signatures on the contract are what make it legal. But it's a good practice to fill in these initials as well. This section, the next section, is for real estate brokers and their agents. And once again, it states that the agent or their broker is not a party to the agreement, and that it is only between buyers and sellers. Talks about the broker's compensation and presentation of offer. The buyer's agent can make a written request to ensure that the seller's broker has presented this offer, and that's what this section pertains to. But these are simply the details of the buyer and seller's agents. And the box below that is for the escrow holder to acknowledge that they've got a copy of the agreement and other details, and then their contact information and all that goes down here as well. The final two sections are for the presentation of offer. That's above when the buyer's agent asks for a written confirmation. This shows that the offer was presented by the seller's broker. And this section here is for the rejection of offer to be completed with the seller's initials, stating that they're not going to make a counteroffer and that the offer was rejected on such and such a date. And that brings us to the end of the residential purchase agreement. Thanks again for joining me for Understanding the RPA Part 4. As always, if you have any questions, please don't hesitate to contact me. I would love to hear from you, and I will do my best to clarify anything that you may have a question about. And again, I'm leaving links for those two reference guides below. And also, if you would like your own copy of a sample of the RPA, I'll leave a link for that as well. And in the next video, we're going to wrap up this series with forms FHDA, the BIA, and the CCPA. In the meantime, I hope you're doing well out there, and if I can help you with any questions, please don't hesitate to let me know. As always, I'm here to help. Thanks.